African Court on People and Human Rights. You are to address the judges as Your Excellencies. The judges are to address you as agents or counsel. We will hear the applicant team first. Well, we do not have respondent team, so we'll hear the applicant team. You have a total of 30 minutes to present your arguments. And you also to note that the judges may interrupt with questions at any time. You are advised to pay attention to the questions so that you can respond directly and concisely. Having said this, I do not know if we have a timekeeper. The host, will you be helping us with keeping the time, watching the time?
Yes, ma'am. I'll be serving as the timekeeper. Ma'am. Okay. So I would drop messages for reminder on the chat box. Yes, ma'am.
Okay. May we proceed? Can we proceed?
Counsel, take out the other device you have with me. If you have two devices in one space, it will echo. Ready. It will echo.
Yes, ma'am. I've done that, ma'am.
Need my mic.
But we would like to inform the course that we'll be using just the device for the oral round, ma.
You're supposed to use a device. Both of you are supposed to be, the oralists are supposed to be in one space. You don't need to use two devices, please.
Noted, ma. Thank you very much, ma.
Your Honor, are you still here?
Yes, I'm here.
Okay,
they seem not to be ready. That's why I'm not. They seem not to have gotten themselves together.
Okay.
Good afternoon, ma'am.
Good afternoon, ma'am.
We are not ma'am. We are Your Excellencies.
Good afternoon, Your
Address
Excellency.
us properly.
We do apologize, Your Excellency. We would love to inform the court that Team 17 is also ready and is currently joining the meeting now, and would like to apologize to the court for our delay in joining the meeting.
Are they available?
Yes, Your Excellency, and the team itself would be joining the meeting right now. We're currently speaking to the court via our lecturer's device, but then we'll be joining you in just about in less than a minute, Your Excellency.
Counsel, what team are you?
Yes, sir. Team 17, the respondent.
What's your name? Your name?
My name personally is PILIWA.
Okay, you just joined us.
Yes, ma'am, we just joined.
Oh, okay. Now hold on. We've already asked the applicants. Are the applicants here? Team 16.
Yes, ma'am, we are here.
The applicants, can we see you? We need to see you.
Yes, ma'am. Our video is on, ma'am.
I need to be sure who I'm speaking with. Are you team 16 or team 17?
We are team 16, Your
Yeah, team
Excellency.
16.
Well, you just said you are team 17.
No, team 17 joined the call very not quite long.
When we were about to start speaking, that
Team
was when team
17 joined the call with Ijiwole, and team 16 is joining this call as Dele Ogundijo.
Yes,
The
ma'am.
instruction is that you rename your device as team 16. That is the instruction. But I think they should just go ahead and address the court. We don't have time.
Okay, so team 17 just joined.
Yes, ma'am, would be joining through, Your Excellency, ma'am, would be joining the meeting as the team through another device. The modalities that were forwarded to us did instruct that we should have a lecturer present, and this is currently our lecturers as an observer, and this is our lecturer's device. However, in about a minute, we would be joining as team 17 through another device, Your Excellency.
Team 17, you are
Yes, ma'am.
far beyond. You've wasted the time of the court. Let me put it that way, and we do not have that time to accommodate these your excuses. So what I would suggest you do now, just listen. In the chat
Yes, Your Honor.
box, write your type your team number, your name, and the time that you'll be using for each oralist. Let's have the team number, the oralist 1, time you'll be using, oralist 2, the time in one message in the chat box. While you are doing that, would ask the team 16, the applicant, to begin. Okay? There's no time for this.
Thank you very much.
So I'm calling on team 16 to begin.
Thank you very much. May it please Your Excellencies, I am AA Owoyemi, and appearing alongside me is OO Bamidele. Our humble appearance is for the applicant. Before I proceed, Your Excellencies, I would like to apologize sincerely to this honorable court for coming late to the court, and this was due to circumstances beyond our control.
Counsel, just 1 minute. Yes, just 1 minute. I understand that you did not. There's no time allocated for your rebuttal, so I would want you to, take out maybe 2 or 3 minutes from your time for rebuttal. So please give us how you want to reallocate your time now before you continue.
Yes, ma'am. So with the kind permission of Your Excellencies, I'll be spending 16 minutes to address the preliminary issues of jurisdiction, admissibility, and as well as the merits of claims A and B, while my co-counsel will be addressing this honorable court on the merits of issues 3 and 4, and we'll also be taking the rebuttals within the remaining minutes, Your Excellencies.
So just to be clear, oralist 1 is taking 16 minutes, oralist 2 is taking how many minutes? 12 minutes, and you have 2 minutes for rebuttals.
Yes, Your Excellencies.
Noted. Proceed.
Sorry to interject, please. Is it Owoyemi that is speaking now?
Yes, Your Excellency.
Okay.
Most obliged, Your Excellency. Your Excellencies, on the issue of jurisdiction, we respectfully submit that this honorable court has the jurisdiction to entertain this application. Your Excellencies, Rule 49 of the African Court Rules provides that the court shall conduct a preliminary examination of its jurisdiction. And in line with the case of Miriam Koma and Anna against the Republic of Mali, the court in that case stated that it shall observe whether it has personal, material, temporal, and territorial jurisdictions. Your Excellencies, it is our submission that this honorable court has the jurisdiction to entertain this application on these 4 cardinal jurisdictions. For the first one being the material jurisdiction of this honorable court, it is firmly entrenched in Rule 29 of the African Court Rules, which grants the court the jurisdiction to deal with all cases concerning the interpretation and application of the Charter and other relevant human rights provisions ratified by the respondent state. Your Excellencies, in this particular case, the violations complained of by the applicant are such that they require and they call for the interpretation of the African Charter, and as well as other international human rights instruments ratified by the respondent state. Your Excellencies, on the second issue of personal jurisdiction of this honorable court, Article 5, Paragraph 3 of the Court Protocol, the African Court Protocol, states that the court may entitle relevant NGOs to institute matters directly before it, insofar as the respondent state has made the declaration, the required declaration accepting the jurisdiction of this honorable court, according to Article 34, Paragraph 6 of the Court Protocol. Your Excellencies, in case whereby the respondent state has not made this declaration, the court will not be able to entertain the matter. However, in this present case, Your Excellencies, it is clear from the fact that indeed the respondent state is already a party to the charter, and they made the declaration as required by the African Court Protocol on August 2nd, 2017. And that confirms the personal jurisdiction of this honorable court. Your Excellencies, on the temporal jurisdiction of this honorable court.
Hold on.
Yes, Your Excellencies.
Your argument that the court has personal jurisdiction.
Yes, Your Excellencies.
I want to know if it is based solely on the fact that the president of EDERA cannot validly withdraw his declaration under Article 34.6 of the protocol.
Yes, Your Excellencies. Your Excellencies, why the applicant admits that the president of the respondent state made an announcement claiming to have withdrawn the declaration, we contend that such an announcement made by the president does not constitute a valid withdrawal of the declaration, and accordingly does not affect the personal jurisdiction of this honorable court. More of it will be discussed under merit A of the under claim A of this application, Your Excellency. But if Your Excellency would like, I would provide more explanation on it, Your Excellency. But later in the course of the
you will
argument,
canvass it. You will argue it further. You can proceed.
I should proceed with the my argument on jurisdiction. Much obliged, Your Excellency. Yes, on the third ground of jurisdiction, which is the temporal jurisdiction, Your Excellency, this honorable court, in the case of African Commission on Human and People's Rights against Kenya, stated that the relevant dates concerning the court's temporal jurisdiction are the dates when the respondent became a party to the charter and made its declaration accepting the jurisdiction of this honorable court. Your Excellencies, it is apparent from the facts of the case that the respondent state ratified the African Charter on Human and People's Rights in 1986, and the protocol was ratified in 2015. It made its declaration on August 2nd, 2017, and the violations complaint began 2 years after the ratification, which was in 2019. Your Excellencies, we therefore submit that the temporal jurisdiction of this court is confirmed by this chronological state of affairs. Your Excellencies, on my submission on the territorial jurisdiction of this honorable court in Lohe Issa Konate against the people of Burkina Faso held that its territorial jurisdiction will not be disputed where the violations complained of occurred within the territory of the respondent state. It is apparent from the facts of this case, Your Excellency, that the violations complained of indeed occurred within the territory of the Republic of EDERA. With Your Excellency's kind permission now, I'll proceed with my submissions on admissibility. Your Excellencies, Article 6, Paragraph 2.
1 minute, please. 1 minute, please. I want to ask, you said the issue of, I wanted to ask you, said the laws of EDERA states that they can apply the laws of other domestic customary international laws as long as it does not conflict with their own laws. Do you understand? And what you are trying to fight is their own EDERAN Criminal Act, Section 16 of their Criminal Act. So if their own constitution is saying that, if their own laws, if the Supreme Court in admitting their customary international customary law is saying that as long as that international customary law does not conflict with their laws, with their own state laws, how do you apply the African Charter law. Do you understand? How do you now say their state should comply with the African Charter law if it's going to conflict with Section 18 of the Federal Criminal Act?
Your Excellency.
I'm referring you to paragraph 4. Paragraph 4 on constitutional guarantee. Look
yes,
at
Your Excellency. Paragraph 4 of the case fact states that the Federal Constitution guarantees civil and political rights in accordance with the African Charter on Human and People's Rights.
Yes.
Yes, so it is on this basis.
Continue reading it. Continue reading it.
Yes, so it also provides that the duly ratified international treaties are part of national law, although not incorporated in the are part of national law. That is to say, if they have been duly ratified, then it makes sense that they are part of national law.
Then so continue reading it. Continue reading it.
Yes, Your Excellency. So it says further that although they are not incorporated into the Constitution, the Federal Supreme Court has recognized customary international law principles to be part of the domestic law in as much as they do not conflict with the Federal requirements.
Law requirements. So that's what I'm asking you about. So how do you now say the African Charter has jurisdiction over a law that you are trying to fight, over a domestic law that you're trying to fight?
Your Excellency, I'm struggling to understand the requirements of the law. Is it the Constitution of the Republic of Edera or the Public Order Act?
Yes, their own law says that their own Edera in the Supreme Court, their Constitution did not ratify, does not incorporate the African Charter law. But the Supreme Court, in admitting other laws, states that as long as that other law that you're trying to implement locally does not conflict with local laws. So how do you conflict? How do you balance that? That's what I'm asking. Do you understand me?
I believe I do, Your Excellency.
Yes.
Your Excellency, the provision, if I understand the provision of this fact clearly, it states that customary international law principles are to be part of the domestic law, although they are not, some of them are not ratified. For those that are not ratified, I believe that is what that requirement of the Supreme Court is talking about, for the laws, for the international law principles that have not been duly ratified. However, the ones that have been ratified are already part of the national laws, making them domestic laws. Therefore, we submit to this honorable court that the duly ratified treaties are also part of the domestic laws, and as such should be treated as being part of the domestic laws, Your Excellency.
They said so far it's not in conflict with the domestic laws, but just proceed.
No, let's
most obliged, Your Excellency. Your Excellency, I'll proceed with my submissions on admissibility of this application. Your Excellencies, Article 6, Paragraph 2 of the Court Protocol provides that this honorable court shall rule on the admissibility of cases taking into account the provisions of Article 56, Article 56 of the African Charter. Your Excellencies, we submit that we have complied with these provisions, especially that of paragraphs 4 and 5 of Article 56, which require that for an application to be admissible, it has to not be based exclusively on news disseminated through the mass media, and also that before an application can be admissible, it must have been after local remedies have been exhausted. On the first note, Your Excellencies, while it is from the facts of the case, we can see that some of the basis for some of the violations complained of are evidenced by publications by truth defenders. We contend that this is not the major reason for the institution of this application. Your Excellencies, from the facts of the case, it is clear that these violations are apparent even without the publications made by the truth defenders. And the government's lackadaisical attitude towards QHL's actions and the plight of the Bashi people is clear, even without these publications. Your Excellencies, is on this note we submit that this application is not exclusively based on news disseminated by mass media. On the second issue of exhaustion of local remedies, Your Excellencies, in the case of Onyachi and Njoka against the Republic of Tanzania, this Honorable Court stated that the requirement to exhaust local remedies is only applicable with respect to ordinary, available, efficient judicial remedies and not to extraordinary or non-judicial remedies. In this regard, Your Excellencies, our submission will be based on two standpoints. The first one being that the requirement to exhaust local remedies should be waived on the issue of the protection of the Bashi people and the child workers, and also on the non-constitutionality of the Public Order Act. And on the other hand, we contend that this requirement has been met with respect to Mr. Jude and Mr. Marcus's conviction. On the first leg of the argument, Your Excellencies, in the case of African Commission against Libya.
Counsel.
Yes, Your Excellency. Yes, Your Excellency.
Are there exceptions to exhaustion of local remedies? If there are, can you kindly tell this court the exceptions to local remedies? You mentioned local remedies, right?
Yes, Your Excellency.
So kindly educate us on the exceptions available for local remedies, if there are.
Yes, Your Excellency. Your Excellency, in the case of African Commission against Libya, this Honorable Court held that the applicant must exhaust local remedies where they are available, effective, and sufficient. Now, further, in the case of Jawara against the Gambia, the court stated that a remedy is considered available if the petitioner can pursue it without impediment. It is deemed efficient if it offers a prospect of success, and it is found sufficient if it is capable of redressing the complaint. Your Excellencies, it is distillable from this case that the exceptions to the exhaustion of local remedies are when it is insufficient, when it cannot be pursued without impediment, and when it is incapable of redressing the wrong. Your Excellencies,
I believe in the instant case, the local remedies were exhausted, so I don't think that's an issue.
Yes, Your Excellencies, most obliged, Your Excellencies. In this case, I would like to proceed on my submissions on merits 1, Your Excellencies.
Sorry. Okay, go ahead.
Yes, Your Excellencies. Your Excellency, claim A is that the withdrawal of the declaration is invalid as it violates the African Charter and other instruments.
Counsel, please.
Yes, Your Excellencies.
Have you adverted your mind to the principle established in the case of Tanganyika Law Society and Tanzania? Do you have an idea of what it says?
I submit to the wisdom of this honorable cause on this matter, Your Excellency. I'm unfamiliar with the case, Your Excellency.
Okay. Are you saying you did not exhaust a local remedy with respect to claim D? Claim B?
With respect to
claim B?
Partially, Your Excellency. With respect to claim B, partially, yes, Your Excellency.
Partially, why?
This was due to Your Excellency, it was due to the fact that the remedies could not be pursued without impediment, and the remedies available could not suffice to remedy the complaint. Your Excellency, it is evident from the facts of the case that when the MAPAO gathered themselves and went to the High Court to complain about their ordeal, the High Court held that despite the overwhelming evidence, the High Court held that the QHL had already paid sufficient compensation, and this decision was upheld at the Court of Appeal. So it was already evident that, and given the corrupt state of the judiciary, it is apparent from the fact of the case that if they had proceeded to the Supreme Court, they would have had the same outcome. The same outcome would have come out. They would have returned home without any remedy, Your Excellency.
Why draw such conclusion? The principle established in that case is that an applicant must visibly attempt to exhaust local remedies. And there was no attempt in that regard.
Your Excellency, I did not get that.
Counsel, your time is up. Your time is up.
Can you let him answer the question?
Okay, ma'am.
Your Excellency, I did not get the question, Your Excellency. Out.
I said that the principle established in the case of that Tanganyika Law Society and Tanzania is that an applicant must visibly attempt to exhaust local remedies. And there was no attempt with respect to Claim B.
Your Excellencies, attempts were made, but without success.
What she's trying to say is that you cannot assume. You must try before you assume. In law, there is no speculation. You cannot speculate that if you go to court, you will not get it. That's also a jurisdictional issue for Claim B. If local remedy is not exhausted, then you will have a problem with jurisdiction. That's what she's saying.
That's true. Then we are hinging on the corrupt nature of the judiciary in Edera. But let's make progress. I understand that your time is up.
Your Excellency, may I proceed with issue B or merits on Claim B, or shall I defer proceeding to my co-counsel?
We'll give you 2 minutes.
Most obliged, Your Excellencies. Your Excellencies, on the Claim B, it's on the fact that Edera violated the African Charter and other human rights instruments by failing to protect the Bashi people and the child workers. Your Excellencies, Article 1 of the African Charter imposes an obligation on states to take appropriate measures available to it to prevent the commission of human rights violations and harmful acts by individuals or business enterprises against its citizens. Your Excellencies, on this note, we submit that the respondent state has failed to protect the Bashi people, and as a result, they have violated their environmental rights, their cultural rights, their right to life, and as well as the children's right to freedom from child labor and economic exploitation. Your Excellency, on the first point, we submit that Edera has violated the people's environmental rights. Section 32 of the Constitution of Edera provides that it is the fundamental objective of the respondent states to protect and improve the environment and safeguard the water, air, land, forest, and wildlife of Edera.
Section 32 is non-justiciable.
Yes, Your Excellencies. However, while we acknowledge that Section 32 is non-justiciable, we refer this Honorable Court to the provisions of Article 24 of the African Charter, which reinforces this provision of Section 32 by providing that all persons shall have the right to a general satisfactory environment favorable for their development, thereby giving that provision of Section 32 the force of law, Your Excellency, being a part of the domestic laws of the Republic of Edera.
Okay, that's very good. I would also have said that Section 32 can be extended, can be expounded to right to life, because if I don't have a right to water, air, land, good environment, then how would I have a right to life? Do you understand? So that can also be brought to like a justiciable right.
I submit to this Honorable Court wisdom, Your Excellency.
Can we make progress?
Your Excellency, moving forward, Your Excellency, we submit to this Honorable Court that Edera violated the people's right to culture. It's on this that most obliged, Your Excellencies. I would love to defer proceedings to my co-counsel to proceed with our submissions.
We propound respect to this Honorable Court and Your Excellencies. I am OO Bamidele. I seek the leave of these honorable courts to proceed on the adoration of the following two issues alongside the conclusion, Your Excellencies. Your Excellencies, the applicant in reliance to the wisdom of this court seeks to know if the Public Order Act of Republic of Edera violates international human rights law. To this imperative question, Your Excellencies, the applicant submits to this court of law that the Public Order Act of Republic of Edera mandating the residents of Bashi to give a 14 days notice to the office of the Inspector General of Police manifestly violate the principle of freedom of peaceful assembly and international human rights. Your Excellencies, the applicant contends that this provision of the Public Order Act is unconstitutional and out of step with international standard. To begin with, Your Excellencies, the Black's Law Dictionary 11th edition was clear. It provided an assembly to be a concourse or meeting together of a considerable number of persons in the same place. This gathering is often temporary and it is often peaceful. Moving forward, Your Excellencies, the right to this assembly has been...
Before you move forward, my dear, before you move forward, Council, are there no limitations? Are there no limitations to protest under international law?
I'll be discussing that very soon, Your Excellency.
Okay, go ahead.
Most obliged, Your Excellencies. Notably, Your Excellencies, this right has been duly protected by Article 20, Sub-Article 1 of the Universal Declaration of Human Rights, Article 12 of the African Charter on Human Rights and People's Rights, and similarly, Article 21 of International Covenant on Civil and Political Rights. This article also recognizes the importance of this right, explicitly providing that no restriction may be placed on the exercise of this right other than those imposed in conformity with the law, and which are often necessary, and this right is necessary in any democratic society. Your Excellencies, it is pertinent to note that as a member state of the above-named international organization, Republic of Edera is bound by these rights, is bound to exercise duties and these rights in accordance to international law. Your Excellencies, peaceful assembly is a fundamental human right that can be enjoyed and exercised by any person. The court was clear in Mulbwana and others against the state, where it described peaceful assembly as including the right to assemble peacefully unharmed. Your Excellencies, the restriction placed on protesters to give prior notice to public authorities before peaceful assembly is carried out interferes with the right of peaceful assembly and expression. The European Court was clear in Wofinka and others against Russia, where it emphasized that this restriction constituted an interference with the applicant's rights, consisting of measures taken before, during, and after the protest. Your Excellencies, it is important to note that the provision of Article 11 of the African Charter and 21 of the ICCPR necessitated that for a government to stop any peaceful protest, it must be able to prove an element that shows that the law passed in this regard has any foundation in the interest of national security. Your Excellencies, the Human Rights Commission in the landmark case of Malawi African Association and others against Mauritania held that the imprisonment of presumed political activities in charges of holding unauthorized gathering constituted a violation of right to assemble, Your Excellencies. The Commission further held that the government did not come up with any elements to show that the accusation had any foundation in the interest of national security. In essence, Your Excellencies, certain conditions has been prescribed by the African courts for a formal notice of protest not to be regarded as infringement. Firstly, Your Excellencies, the court in Williams against Zimbabwe laid down the requirements of legitimate aim. Your Excellency, it means that the restriction shall be limited to those listed in Article 11 of the Charter, which includes the public safety, public order. Your Excellency, the court was also clear in Jennifer Williams and others against the Republic of Zimbabwe, where it emphasized the importance of necessity and proportionality in restricting freedom of assembly. Notably, Your Excellency, the lack of prior notification should not automatically lead to criminal sanction or dispersal. The failure to notify should not make an assembly unlawful and lead to dispersal or criminal sanctions.
Please. Hold on, Council. Hold on. With respect to proportionality, which other measures would have been employed by the respondent? Which other measures do you consider proportionate?
My lord, this council believes that the government could have taken other means to address the protesters. There is a way
I'm
they can
asking for those other means.
They can speak to the leaders of the protests, Your Excellency. They can
In the heat
bring
of agitation?
Your Excellency, the issue of this
What
case.
is your definition of proportionality?
Your Excellency, my personal definition of proportionality means that by the time they are against, they are coming to stop the protesters from causing further violence, the action they are taking against them should be proportional to any actions that the protesters has engaged in. If the protesters are engaged,
can I have
yes,
just a definite measure described by you as proportional?
Your Excellency, they could not have gone there with tear gas to disperse the crowd. They could go there, they could simply go there to address the crowd. And if the crowd in turn changes on them or turns out on them, then they can take other measures. The first measure they took was the use of tear gas on the protesters.
Go ahead. Proceed.
Replied Your Excellency. Your Excellency, given the above, the Republic of Edera lacks a well-grounded legitimate aim for the application of Section 13 of the Public Order Act. The protest was organized by the people of Bashi to show their displeasure to the act of QHL and the refusal of government to intervene. Thus, there is no legitimate ground for the notice required by Inspector General. Assuming Aguendo, Your Excellency, a legitimate aim was provided by the Republic of Edera. The element of necessity and proportionality was not duly complied with by the Republic of Edera. The court in Woza against Republic of Zimbabwe emphasized on the principle of less restrictive measures before interfering with assembly. The failure to give proper notification where required should not result in dispersal of such assembly, Your Honor, Your Excellency. However, the police of Republic of Edera on the day of the protest deployed to the protest venue to disperse the protesters with tear gas, which led to the injuries of several passers-by and protesters, Your Excellency. Based on the foregoing, the applicant respectfully submits that this act portrayed by Edera manifestly violates the right of freedom of assembly and expression of people of Bashi in contravention with several international human rights law. Moving on, Your Excellencies, this council would like to proceed on the adoption of the last issue, which poses a question of whether Edera has violated African Charter and other relevant human rights instruments by the various treatment meted out to Mr. Jude and Mr. Marcos. On this issue, my lord, the applicant submits that the use of live ammunition by the respondents to disperse the protests led by Mr. Jude and Mr. Marcos and the further arrest of these parties, detention, arraignment, and sentencing without fine was disproportional, unjustified, and in contravention with international human rights law treaties, Your Excellency. The applicant contends that this act constitutes a blatant violation of Article 6 of the African Charter, automatically triggering a violation of Article 1 and Article 2 of this same charter. Your Excellency, Article 14 of the ICCPR has also been violated. Furthermore, it amounts to torture in violation of Article 1 of the United Nations Convention against torture and other cruel, inhumane, or degrading treatment or punishment, Your Excellency. Following Article 1 of the African Charter, Your Excellency, the Republic of Edera, as a member state of the Organization of African Unity, is bound to recognize the right entrenched in the Charter. Any failure to abide by this provision constitutes a violation of the Charter, as established in the case of Dauda Jawara against Zambia. On the basis of the aforementioned, the applicant argues that the party's rights to liberty and security, as guaranteed by Article 6 of the African Charter, was violated. This article stipulates that every individual has the right to liberty and security of person, prohibiting arbitrary arrest or detention. The respondent's failure to uphold this provision constitutes an infringement of the party's entitlement to this right, and also underscores the provision of Article 2 of the African Charter. When a deprivation is arbitrary, it constitutes deprivation of human rights. Hence, the court in Oyachi and Unjoka against Tanzania commented that The notion of arbitrariness under Article 6 of the Charter also covers the deprivation of liberty, arbitrary arrest, and the standard of reasonableness. That is, it is pertinent to inform the court whether such arrest is just, is necessary, proportionate, and equitable. This has also been established in the case of Mukang against Cameroon. Moving on, Your Excellencies, an established international...
Counsel.
Yes.
Counsel.
Yes, Your Excellency.
Is it on purpose that you failed to address this court on Claim A? I was thinking you were reserving it for the last.
My Lord, the network was quite Your Excellency, the network was quite unstable. Could you kindly reiterate the question?
Said, is it on purpose that you do not have any submission on Claim A?
Your Excellency, Claim A and Claim B was supposed to be handled by the First Council. However, times did not permit the First Council to handle the Claim A and Claim B. So it was my duty to address the Claim C and D, which is if the Public Order Act of Republic of Edera was in violation of human rights instruments, and the last, which I'm currently addressing.
You would have merged them as a wise council. A wise council would have merged so that nothing is lost. Go ahead.
I submit to the wisdom of this honorable court.
Proceed.
Most obliged, my lord, Your Excellency. Moving on, an established human rights jurisprudence does set 3 cumulative criteria to determine whether or not a particular deprivation of liberty is arbitrary, and they included the lawfulness of such deprivation, the existence of a clear and reasonable ground, and the availability of procedural safeguards against arbitrariness. Firstly, on the criteria of lawfulness of the deprivation of personal liberty, the applicant respectfully submits that this requirement has not been established. For an arrest to be considered as arbitrary, it means it does not have any legal basis. Your Excellency, any deprivation of liberty must have legal basis and should be carried out in accordance with the law. In this case, Your Honor, Your Excellency, the respondent arrested the protesters mainly because they organized protests. It has been clearly provided that this scenario turned violence because the police who were supposed to disperse the protesters were unable to quell the protests. The reports did not post Mr. Jude and Mr. Marcos as an instigator of any crime at the protest ground. Hence, the applicant respectfully submit that the arrest...
You have just 1 minute. 1 minute. Your time is up, but just 1 minute.
Much obliged, Your Excellency. Your Excellency, additionally, Article 6 of the African Charter also did not explicitly create a clear definition of clear and reasonable ground. However, the use of the word reason and condition in this section implies that the detention of such person should be based on adequate justification. My Lord, Your Excellency, this was applied by the court in Money, Eligard, and others. In the present case, the grounds for arresting Mr. Jude and Mr. Marcos leading a protest are insufficient and is in contravention of Article 11. Furthermore, Your Excellencies, the applicant contends that the criteria of availability of procedural safeguards against arbitrariness is absent in the Republic of Edera. The judiciary, who are empowered with the duty of transparency and impartial decision-making, has been reported by Truth Defenders, a newspaper, to have been heavily influenced by the big corporations and influential politicians. Hence, there is no available safeguard against arbitrariness in Republic of Edera. Notably, Your Excellencies, the inadequacy in the judiciary system of Edera is not only a fulfillment of the third element that constitutes arbitrariness, but also a violation of Article 14 of the International Covenant on Civil and Political Rights. Moving on the use of live ammunition in this case and harmful substances for dispersal, further causing bodily harm to over 30 persons, and the further arbitrary arrest of the protesters for 4 days without trial, restricting their movement and freedom, all constitute deprivation.
You have addressed us on this. Yes.
Conclusively, Your Excellency, the applicant respectfully praises honorable court to find judge and declare that the court has jurisdiction and the case is admissible. Edera's withdrawal of its declaration under Article 34 of Article 6 is invalid. That Edera violated African Charter and other human rights instruments by failing to protect the Bashi people, that the Republic Order Act violates international human rights law, and Edera violated the African Charter and other relevant human rights instruments. Applicants can so respectfully submit to the wisdom of this court.
Okay, thank you. Thank you, applicants, for your submissions. We call on the respondents to make their presentations and arguments.
Team 17, are you here? The respondents, are you here? Okay, while we're waiting for them, Your Excellencies, Team 17, they've put in their details in the chat box. We can get the details, their name and the time and location on the chat box for Team 17.
Excellency. Good Excellency. Good afternoon, Excellency.
Can we meet you, Team 17? Can we see you?
We apologize for the interruption in network in connections, Your Excellencies. Good afternoon, Your Excellencies. This is Team 17.
Team 17, you can't have more. Have just one device, you know, that you are using in a space. One device. Otherwise, it will echo. Then position your camera properly. You wouldn't want Your Excellencies to be turning their neck to be able to view you.
That is exactly what I've been doing.
Team 17. Right, network. No, Team 17, we are waiting. Fellow judges, let's give them a little time to get stable with their network. Hello?
They are here, but we can't hear.
Yes,
they are
we're
not
waiting.
speaking. Yes. Team 17 is here, but they are not speaking. I guess it's still the network issue.
Okay. Your Honor, are you here?
I'm waiting. I'm waiting for them. Yes, thank you,
Dr.
ma'am.
Tunu? Dr. Tunu, are we together?
Yeah, I'm here. We are here, ma'am.
Okay. Okay, let's give them some time to get their network stable. The host, can you reach out to them?
We're doing that, ma. We're doing that.
Of course. Good afternoon, Your Excellencies.
Good afternoon. Good to have you, Team 17.
We do apologize for the issues we've encountered so far. Network in this part of the world has been very questionable.
Please, let's start why the network is stable. Please, let's start. Thank you.
Okay.
Progress.
With the most profound respect to this honorable court, I am Kade Oluwapelim Samuel. Appearing with me is Adegbore Adegbingbe, and we are appearing for the respondents. We are the counsels for the respondents, Team 17. And would be going straight into our argument before this honorable court.
This one is not ready.
As regards the matter before.
Okay.
Go ahead,
As
please.
regards the matter before.
Go ahead.
As regards the matter before this honorable court. The first of our arguments is on the question of jurisdiction. And the respondent argues that this honorable court currently does not have jurisdiction over the applicant, which is currently does not have jurisdiction to hear this matter. This is due to the fact that the withdrawal of Article 34.6 is currently valid, and the applicant
it's showing that their network bandwidth is slow.
Only from Edera's.
Okay, Mr. Somi is taking me back to that place to start.
And Edera exercises its sovereign prerogative to withdraw that declaration.
Okay.
And we did exercise it on August.
I think they are lagging. It's I can't really hear what they're saying because it's like it's lagging. I don't know.
It's stable. Go ahead. It should be stable. Let's hear you. Oh, it's still lagging. It's lagging.
Your Excellencies, Team 17 will request permission to currently continue its argument if the court pleases.
Continue. On what?
On the first of the issues before this court, which is jurisdiction, and we do believe, as the respondent does believe that this court lacks the jurisdiction to hear this particular matter, Your Excellencies. Your Excellencies, the respondent would continue with our argument. And our argument is that the withdrawal of Article 34(6) declaration of the Edera Constitution is valid, and the applicant is currently standing solely on the already withdrawn article, which is Article 34(6) of Edera's declaration. Edera exercised its sovereign right to withdraw that declaration on August 15th, 2025, and the applicant's case was only registered 7 days later on August 17th, on August 22nd, 2025, Your Excellency. The African Court Protocol is very silent on the prohibition of withdrawal as a matter of general international law, and Article 56(2) of the Vienna Convention of the Law of Intention is consistent with the voluntary nature of the said treaty, which means that the right to accept or decline the jurisdiction of this court is inherently and unquestionably the attribute of sovereignty, which the state of Edera would like to exercise.
Counsel, before you proceed.
Yes, Your Excellency.
Does the withdrawal of Article 34(6) take immediate effect?
You said what, Your Excellency? I'm sorry.
The withdrawal of Article 34(6), which you have made submissions on, does it take immediate effect?
Yes, Your Excellency.
Does it take immediate effect?
Yes, Your Excellency, it does.
It does. Okay. Do you have any authority on that? Okay, make progress. It appears you are distracted. You have a whole lot of distractions.
Your Excellency,
you have distractions.
You for the network is quite questionable.
All right. Go ahead.
The network is quite questionable. We do apologize, Your Excellency, and we apologize to the court. This very
proceed.
Court, the judicial president will be presenting before this very court is the case of the African Commission, the case of the African Commission versus Rwanda. The court recognized the right of states to withdraw their declarations, provided due notice is given. And the Republic of Edera did fulfill the procedural requirements by announcing the withdrawal publicly and depositing this with the African Union Commission, with the AU Commission.
Can you refer me
the withdrawal took place,
Counsel,
took effect immediately, and thus prevented new cases to be filed after the withdrawal.
Council.
And our argument and our submission on the question of jurisdiction cannot rely on vested rights on therefore our conclusion is that the withdrawal was a lawful political decision without jurisdiction. Yes, Your Excellency.
Can you take
I can
us
hear you, Your Excellency.
Okay, please take us
Your Excellency.
to the facts.
Hello, Your Excellency.
Take us to the paragraph of the facts where the announcement was declared or
All right, Your Excellency, we'll be doing that now.
made a network. Please proceed.
Your Excellency, would be proceeding with our next argument, which would be the admissibility of this case. This application by the applicants fails the basic test of admissibility, as the applicants failed to exhaust the domestic remedies provided in EDERA. Article 56, sub 5 of the African Charter and Rule 50, sub 2 of the court rules require the exhaustion of all available and effective local remedies, and the applicant has failed fundamentally in this. Also, as confirmed in Tanganyika law versus Tanzania, dissatisfaction with domestic outcome does not equate to effectiveness. And the principle of subsidiarity obliges parties to respect domestic judicial process. The applicant also failed to pursue constitutional review or an extraordinary appeal to the Supreme Court of EDERA. And the Supreme Court is the final competent forum to hear human rights complaints. And this failure to pursue the highest domestic remedy is very fatal to the admissibility of their claims before this honorable court. Permission to proceed, Your Excellency. Sure, Your Excellency.
Please proceed now. You don't need our permission to proceed. Please, while the network is stable, let's go on. Let's make progress. Thank you.
Okay, okay, go ahead.
The claims by the applicants before this honorable court are also time barred. According to Rule 50 sub 2F of the court rules, submission is required within a reasonable time after exhaustion of domestic remedies. While the last domestic judgment was delivered on May 1st, 2025, the applicant seeks reviews of events that occurred as far back as 2019. And this unnecessary and undue delay in challenging those old violations renders this
claims totally inadmissible as
Counsel,
by this very court in the case of APDF and IHRDA. Yes, Your Excellency. Yes, Your
Are you
Excellency.
saying that the issues you raised, that there were unreasonable delay?
You said what, Your Excellency? Sorry, Your Excellency.
Are you saying that the issues you raised were unreasonable delay? Or are you talking about limitation, statute bad, time bad?
I'm talking about time bad, Your Excellency.
Okay, please, can you address this court on the difference between statute of limitation and unreasonable delay? Under international human rights law.
Sure, Your Excellency. Please, can you come again?
Address us on the difference between statute of limitation and unreasonable delay under international human rights law.
Your Excellency, a statute of limitation is a fixed, predetermined time period as set by legislation.
Okay.
And according to, once time expires, the claim is irreversibly barred. However, unreasonable delay is not fixed to a statutory period.
Are you arguing that
is determined case?
Are you arguing with respect to occurrence or when decision was taken?
Sorry, Your Excellency, you said, am I arguing based on
occurrence of events or when decision was taken?
Your Excellency, we're arguing based on occurrence of events. These events happened as far back as 2019, Your Excellency.
You may proceed.
Thank you, Your Excellency. Our submission on the question of admissibility is that for the reasons we have presented so far, the application by the applicant is rather inadmissible due to the fact that they did not exhaust all legal remedies as provided by municipal laws in Edera, and also they filed this matter before this court at a very late date, Your Excellency. And my final argument as lead counsel for the respondent is that the respondent has in no way violated the African Charter. And the respondent, even on merit, has fulfilled its obligations under the African Charter. Edera's due diligence on QHL and child workers issue 2. The state's duty under Article 1 of the Charter is one of due diligence to take reasonable measures, not of strict liability, as affirmed in the case of Rodriguez versus Honduras. And the state of Edera made sure to comply with this, of exercising due diligence. Also, the state of Edera provided remedial action following the 2019 incident. the government established the Jacob Jeffrey Commission, whose recommendations were fully implemented. This included the suspension of unsafe mining, persecuting erring officers, and providing compensation. These very actions by the respondent constitute effective remedial action, Your Excellencies. Also, on child labor control, EDERA has ratified the International Labour Organization Conventions 138 and 182, and the EDERA Labour Code prohibits hazardous work for children. And the alleged residual violations by the applicant occurred within the informal mining sector. And EDERA's policy partnerships with UNICEF and the International Labour Organization demonstrate due diligence in policy implementation and compliance with international...
Council.
Yes, Your Excellency.
Please kindly take us to the paragraph. Take us to the paragraph of the facts where what you just submitted is reflected.
Your Excellency, you said?
You heard me.
I believe you did say the paragraph.
Yes, take us to the paragraph. Yes.
What I just...
Yes. Submission. Yes. Yes.
Is reflected.
Talking about UNICEF and ILO.
The EDERA constitutes paragraph 4 of the Act, civil and political rights in accordance. It also provides that duly ratified international treaty of the facts of the case says the Republic of EDERA is a member state of the United Nations, the African Union, and the Economic Community of West African States.
Please proceed.
Proceed with the paragraph.
Go ahead with your arguments. Go ahead. Go ahead.
All right, Your Excellency. And our argument continues that the Public Order Act is lawful and proportionate and is compatible with the African Charter and is not an inherent human rights violation. Article 2 and other rights in the Charter are subject to limitations under Articles 27 sub 2 for the protection of national security, law, order, and public morality. The legitimate regulatory measures that occurred. On the question of proportionality, the Act does conform to international standards of necessity and proportionality. The African Commission in Media Rights Agenda versus Nigeria acknowledged the required if reasonable and necessary.
Council, I hope your arguments are in line with the claims. of this court, because so that we are all on the same page. There's an indication that your time is up. Your co-counsel will continue from where you stopped. But let us know clearly the claims.
Sir, Your Excellency, you said?
Yes.
Sir, Your Excellency, we lost you for like a minute there.
Oh, it appears your time is up.
All right, Your Excellency.
Yes, we needed to know the where your argument is hinged. You know, let us know the claims, you know, under which you are making your arguments. You specify. Go ahead.
Your Excellency, due to the fact that Your Excellency, due to the fact that I have expended my time, my co-counsel would, with the permission of the court, be proceeding into our argument and also addressing the claims which our arguments follow on.
Okay.
To this honorable court, I am A.O. Adegore, and I seek the leave of this honorable court to take the relief sought for this case. May I proceed, Your Excellency?
Reliefs?
Yes, ma'am. Okay. That's my part. Yes, ma'am. On issue 1, as to whether the withdrawal of Article 34, sub-Article 6.
I thought reliefs we are predicated on reliefs are supposed to be.
We are.
Oh.
My lord, Your Excellency.
Are you talking about reliefs or merits?
My lord, what I'm taking the relief, my lord. And may I proceed, Your Excellency?
You can reluctantly proceed, but we needed to hear your arguments on the merits. Go ahead.
Okay, thank you, Your Excellency. My lord, I would like to say, Your Excellency, rather, states have an inherent sovereign right to withdraw optional declaration Article 34 sub-Article 6 is optional. These principles flows from the VCLT articles of optional treaty mechanisms. The African court recognized in Igbariye versus Igbariye Victory legitimate, provided that notification of Edera issued a presidential decision 25 and publicly announced applied by the court in Rwanda's withdrawal. If after reasonable notice period, Your Excellency, the court held that a 12-month notice is necessary for legal certainty, as seen in the case of African Commission versus Rwanda. Thus, the Republic of Edera's withdrawal becomes effective on 15th of August 2026. The court should decline jurisdiction out of sovereign respect Although the court technically retains jurisdiction for 12 months, the respondent submits that Article 34, Sub-Article 6 is purely voluntary act. Once a state communicates withdrawal, jurisdiction becomes tenuous and should not be expansively extended to sovereign restructuring of international commitments. My Excellency, I would like to state that no vested right exists in a particular forum. The African Court held that individuals have a right to a remedy, not to a specific tribunal. Hence, Republic of Edera's withdrawal is valid and legally effective, and the court should decline jurisdiction and dismiss relief A, my lord. I would like to go to the second relief, Your Excellency. May I proceed?
Ahead, though. Go
Your
ahead.
Excellency.
Go ahead.
On whether the Republic violated the rights of the Bashi community and child workers, Republic of Edera exercised due diligence and cannot be internationally responsible. The state took all reasonable measures required under the Charter. This conducted a lawful EIA, facilitated voluntary according to Article 23, established the dismissed offending offenders, suspended QHL, and mandated safer mining, coordinated and compensation, my lord. In Serac versus Nigeria, due diligence requires reasonable measures, but not absolute prevention. My Excellency, the Republic did everything they could as regards to this matter. The 2019 violence was triggered by private actors and not state agents. TALT escalated the protest into violence, and international law recognizes that states are not responsible for private acts unless they are acquiescent. States are responsible only for where they fail to take reasonable steps. And in this particular case, Your Excellency, the Republic did not take reasonable steps. As to whether child labor was not attributable to the Republic under Articles 5, 6, and 18 of the Charter, Your Excellency, child workers were in informal artisanal mining and not QHL. The EMB investigated and found no evidence linking the states to this particular matter, my lord, as well as QHL. And QHL acted promptly and partnered with UNICEF.
Hold on. Cancel.
Sorry, Your Excellency, ma.
Does Edera's failure to regulate private corporations like your QHL not amount to its complicity in the violation alleged?
Your Excellency, ma, as stated earlier, the Republic on the matter took due diligence and reasonable measures, but absolute prevention is not certain, my lord. My
Go ahead.
Excellency, Your Excellency.
Go ahead. Go ahead.
Rather, sorry.
Go ahead.
No. This was Your Excellency, ma'am, may I continue?
Proceed.
Your Excellency.
Go ahead. Go ahead.
Network is bad. Your Excellency, ma.
Go ahead. Go ahead.
The network is lagging. Thank you, Your Excellency.
Go ahead. Go ahead.
I'll be so we can hear you. Please go ahead.
Leading to the next one as to whether domestic remedies were not exhausted in line with your question. MAPOA approached the High Court and the Court of Appeal, and they never filed a constitutional challenge of separate environmental or child labor case. In conclusion on issue 2, Your Excellency, the Republic fulfilled its obligation in due diligence, even with QHL. No violation is established and relief B must be dismissed. Thank you, Your Excellency. I'll be proceeding to the third issue as to whether the Public Order Act violates the charter. Your Excellency, the network is lagging. I want to know if we're on the same page, Your Excellency. Can you hear me now?
We are together. We are together. Proceed. Progress with
our position is that the Public Order Act is proportionate restriction with international standards. Limitation on assembly. Articles 9 to 11 expressly allow restrictions necessary for public order. In Media Rights Agenda versus Nigeria, restriction.
Article what?
Prior notification is internationally recognized. The act is content neutral and non-discriminatory, as the applicant provided no evidence of selectors violated.
Sorry, you said article what?
The notice requirement. They knowingly proceeded without the statutory notification. The protest became violent, burnt vehicles to the ACHPR guidelines protection. Your Honor, the applicant failed to challenge the act. The African Court can honor. Your Excellency, the Order Act is lawful, necessary, and proportionate in line with international standards. Please go now too. Network is lagging. Can you hear me now? Your Excellency. Your Excellency, ma.
Go ahead. Go ahead.
The network was lagging. I was trying to respond. Okay, thank you, Your Excellency. On the last issue as to whether treatment of Jude and Marcus violated the charter, my lord, their arrest, detention, and conviction complied fully with Articles 6 and 7. The arrest was based on reasonable suspicion as they organized unauthorized protests. Not only that, they received full trial and they were given an opportunity to be cross-examined. And it was heard before proportionate within statutory limits as they received minimum of 3 years, and the Section 8 prescribes 3 to 5 years. The African Court cannot act as a fourth instance. The final conclusion I humbly pray to this honorable court is that
will leave A, B, C, and D be dismissed. This is because there was withdrawal of Article 30. The withdrawal of Article 34 of Article 6 is valid. No violation of the right of the Bashi community or child workers were violated. The
Time
Public
up, Council.
Order Act is
Time
lawful,
up.
proportionate, and thank you, my lord.
Can we have team 16 for their rebuttal? Welcome back. You have 2 minutes.
I seek the leave of this honorable court to refer the proceedings to my co-agents.
Go ahead.
Most obliged, Your Excellencies. Your Excellencies, I will be rebutting the argument of the counsel to the respondent when they said that the declaration is valid and that it is effective. It is of immediate effect. Your Excellency, will be. It is our submission that first the declaration, the withdrawal of the declaration is invalid, and that were it be valid, it cannot be of an immediate effect. First, on the validity of the withdrawal of the declaration, we submit to this honorable court that the president who made this announcement does not have the power to do so, and as such, his action is ultra virus. Your Excellency, Section 17 of the Constitution of the Republic of Edera states that the president has the power to ratify treaties. However, this power of the president is restricted when it comes to the matters that concern membership of international organizations or affect the vested rights of adherents. In this case, it can only be ratified upon approval by the parliament. Your Excellencies, this provision should, well, it is our supposition that this provision should also be interpreted as to extend to the president's power to withdraw such international agreements and treaties. Therefore, the president could not have validly on his own withdrawn the declaration of Article 34, paragraph 6. Secondly, Your Excellency, such announcement is invalid as it's invalid. It cannot be effective immediately because, Your Excellency, in the case of Ngabire against the Republic of Rwanda, the court held that with regards to withdrawal of declaration under Article 34, paragraph 6, a prior notice of 1 year is required. Your Excellency, according to the court in this case, the declaration is once made, it constitutes not only an international commitment, but it also creates subjective right to the benefit of individuals and groups, and as such, the requirement of notice is necessary. Your Excellency, we therefore submit that the withdrawal of the declaration would prevent the enforcement of the bundle of rights guaranteed under the African Charter and other relevant human rights institutions instruments. We so humbly submit, Your Excellencies.
Okay, thank you for your submissions.
Mr. Obliged, Your Excellency.
Okay, at this point, we'll be calling on the judges. Your Honor. Dr. Itunu. Dr. Itunu.
Good afternoon.
Your Honor.
Good afternoon, ma. Yes.
Okay, carry on.
Okay. I want to say that the second team, I wouldn't say I was able to because of the lagging, I wasn't able to go ahead with what they were saying effectively. But for the first team, fine. I think that to an extent you understood your brief, you knew how to deliver, but for some of the legal issues, so for some of the case laws, I don't think you were very in depth on it, but you knew what your brief was and you were able to carry on. But for the second team, I can't say much for it because it was lagging and I wasn't able to go along as effectively as I should have gone along with it because of the lagging. Thank you.
Okay, thank you very much, Tolu, Your Honor. We are grateful for those remarks. Dr. Itunu,
Yes,
can
ma'am.
we have you?
Good afternoon, everybody. For Team 16, I think that they did well. Well done, both teams 16 and 17. You've done wonderfully well. For 16, the oralist too canvassed the arguments well, and she was passionate about it. And I think that she demonstrated or she understood the facts of the case, and she did well. But the problem I have with the team was the background movements were just too much and distracting. People were going up and down, and several things happening behind you. For if you still come before us, please ensure that you minimize background movements. It can be very distracting. Several people moving up and down, picking things behind you. I think that is not so good. So please, let's work on it. For Team 17, the beauty of advocacy is not in reading from prepared books, as in it's never in reading from prepared books. You can have key points, but not that you make it obvious to us that you're reading. As it's so obvious that as you are flipping through the pages of the notes in front of you, we can hear, we're seeing it. So for next time's sake, I would advise that you'd have sticky notes, you have things that would remind you, that will prompt you on what to say and what not to say, and not that you are like reading things before us. It's not so nice. I think please let's work on that. And then our arguments too, if questions are put across to you and you don't have the answers, it's not a crime. You tell us you don't know, and then we move on. But don't struggle with answering questions that you don't have answers to. And then for one of the oralists, I don't know if it's oralist 1 or 2 now for Team 17, please get how to address these courts well. You were addressing us as My Excellency, My Lord, Your Honor, and different things. Please let us know how the proper way to address the courts the courts that you are before. Let's be sure of the language of the courts. It will help us moving on. Thank you. Well done, Team 16 and 17. Thank you. Thank you, Dr.
very much.
Thank you. Yes, ma'am.
Thank you. Okay. Let me start by appreciating the two teams for their efforts. I would like to say that preparedness is essential in every assignment. There was no indication with respect to time. We should be holistic in addressing you so that going forward, you will come up better. You ought to have been in the call 20 minutes before time, and not to have the judges waiting for you. I also encourage you to take up this competition, take it up committedly as a learning experience and give it your best. Talking about the way and manner you address the court, you should be consistent in the way you address the courts, knowing that you are appearing before the African courts and not the regular courts. Your composure also matters. Of course, the issue of movement had been stated. But generally, I want to thank you all for participating in this competition, which is very crucial for developing future giants and champions in human rights in Africa. This competition provides opportunity to translate legal theory into practical advocacy. You know, when we do this, we find out that we deepen our understanding. You have a broadened understanding of human rights. You have your skills sharpened. Now, for the teams, you should take note of the questions that we are asked. We may not start revealing the lapses, so that going forward, let me hide under the remarks that have been made by the other judges. Team 16 tried in making their presentations, but they still need to have firm grasps of the facts and even the laws. Also, Team 17, I was listening to you, but I almost did not even understand the angle. I just had to carry on. You said you were making a presentation of reliefs, and then you diverted and all that. The essence of this competition is for us to learn. Nobody is a compendium of knowledge. We are here to learn. So you go back and try to polish your advocacy skills and deepen your understanding of international law and human rights law, so that going forward you won't have to falter, or you won't have to get this. So in the absence of any of the judges, for their time and their efforts, and for staying up till this time, despite the hitches. Thank you very much.
Thank you so much, man. Thank you. Very grateful.
Thank you, ma.
You're welcome, Your Honor.
Okay, we would ask the teams to exit the group, exit the virtual court. Team 17 and team 16, kindly exit. I would like to thank Your Excellencies for, time that we have spent to listen to these groups, despite the issues that we had. I will begin by appreciating Your Honor for the patience, and also appreciate the presiding judge, Dr. Shoma Iteshi, and Dr. Etinu as well, who had to step in, at the last minute. Thank you very much. We are deeply grateful for the time. I don't know if there's any comments before we call this session a close. Your Honor, please, any comments?
Sorry, I'm actually in another meeting. Like, muting another one. Sorry. Thank you for the opportunity, and I'm happy that this kind of thing is being done, because is good for legal education and also for improvement of our standard of education. The fear is that Nigerian education system is going down, but when you hear things like this and things like this are being done, then it gives a lot of confidence. And I'm happy that at least the students, they know a few things, they know some things, there's a bit of confidence there, and it's something that is exciting and a bit heartwarming. Thank you very much.
Thank you very much, Your Honor. Dr. Choma, Iteshi.
Just to thank you for I want to say thank you for the opportunity. We are all in other sessions and other competitions. Sure, you are taking notes. Sorry, you are taking notes.
Yes, I am. I am.
You are taking notes, not just for this particular session, but for the entirety of what
yes, ma'am.
All that have been going on. So thank you. It's really an opportunity for us to hone our legal analysis and then sharpen the advocacy skills of our students, then expose them to becoming giants and champions, future giants in the issue of human rights and international law. Even the judges in making preparations for the sittings are also learning. So we thank you for the opportunity and trust that it keeps getting better. Thank you very much.
Thank you, ma'am. So now I know Dr. Itinu is somewhere close to where I am. So I know she's smiling. I can see from the video. So I believe she's also saying, aligning her thoughts with what you've said so far. So we would have to call this session a close. Thank you very much once again.
Thank you, ma'am. Thank you.
Thank you.
Okay, when are you expecting the results?
Ma, if you can send it now, it's okay. If you have it ready, just send us a scanned copy. Otherwise, before the end of today. Yes, ma'am.
Okay, thank you. Your Honor, carry on with your meeting.
Yeah. Thank you very much, ma. Bye.
Bye.